May I mention one matter? Mentioning for inclusion, my lord. WPA 26894 of 23.
Lordship, may I be permitted to mention, I have given notice to the other side. I'm praying for upgradation of a matter. There's certain urgency in this matter. Item number 30.
Give your slip, we'll see that.
Your Lordship, may I be permitted to mention one matter for upgradation, Lordship? Monthly is item number 107.
Give your slip, madam. We'll have a look.
My lord, my lord, if I may I be permitted to mention one matter under extremely urgent circumstances, my lord. Despite a division bench of this honorable court has given liberty to the petitioner to file an appeal before the regular court under the West Bengal Municipal Act 1993, the respondent municipality has served a notice to the petitioner that they will.
Have you
No, my
served
lord.
them a notice?
No, my lord, the notice has been served by the municipality.
Have you
yesterday.
served them a notice of mentioning, sir? That
No,
you're
my
gonna
lord,
mention?
I didn't get the time, my lord. Kindly consider. I will serve
Sorry.
if my lord keep the matter
Serve
on
them,
Monday.
then mention it.
My lord, they will come on Tuesday, my lord.
Claim your damages, whatever you have to do. Yes.
Sir, may I mention this matter? Lord, Lordship will recall, my lord, I mentioned this matter. Lord, under section 408, a demolition exercise has begun. Now, Lord, we have received the intimation day before yesterday from the police station. Now,
Yes.
Lord, all I am praying is, Lord, some time may be given to vacate the premises. But all of a sudden, this demolition process is beginning.
Yes, Mr. Mukherjee.
Your Lordship recollects on Monday I mentioned there's some urgency in the matter. Your Lordship was graciously pleased to allow my mentioning matter has come. But my lord, the communication of the executive engineer is hanging like a Damocles sword on my head. On 6th, a communication was given, giving me time for 7 days to
This
leave
is
the
that-
premises for the purpose of demolition, overreaching the order of the municipal commissioner. When I move the matter, your lordship would see.
You're the tenant.
I am the tenant holding 4,500 square feet
2008, the first demolition order was passed.
was passed. And the last one is 2015, against which there's an order.
What, Mr. Mukherjee, this building can collapse. This building can collapse any day.
I'll show. Malad gives me 5 minutes. If your lordship feels that what has fallen from your lordship, I will not urge a single line thereof. Let me place the order of the municipal commissioner.
You have
And
not
the-
even challenged the order of the municipal commissioner.
This in my favor. I cannot challenge it. But the subsequent communication is Malad misinterpreting that order and overreaching the order of the municipal commissioner. Your lordship just gives me a time 52, in all probability will not reach. If your lordship would give me time at 2, then I can just for 10 minutes, your lordship give me time at 2 after the research.
Won't be possible today, Mr. Mukherjee.
Before rising, if your lordship gives me 10 minutes
Today,
time.
we'll have it then at 12 o'clock.
Very good, Malad, I'll try and
After
give
12.
notice, my lord, Mr. Ghosh is appearing.
Give notice if he's around, we'll.
Yes, I'm giving no. I'm giving. I'm
Yes.
giving.
Call out the
Grateful,
list.
my lord.
My lord, may I seek my lord's leave, my lord, to mention one urgent matter. My lord, on 17th of June 2025, there was an order by the coordinate bench asking the municipality, my lord, to, my lord, file a report. My lord, the report has not been filed. My lord, I am not, my lord, in a hurry to demolish the building. It's an absolute unauthorized construction, G+4 sanction plus obtained. G+8 construction has been raised. My difficulty, my lord, before your lordship is only to this respect. I am the adjoining owner of the building. And my lord, for their water content and my lord reservoir, the entire boundary wall has been demolished. My lord, broken. So my lord, and every single day, my lord, bricks, stone chips, everything is falling on my balcony, on my
Mr.
roof.
Mandal,
My lord, I'm
give your
not being
slip,
able
we'll see
to.
that.
My lord.
Give your slip, we'll see that.
My lord, kindly, my lord, to be mentioned if could be it on Monday, my lord. Let it be
Not
demolished.
at all.
My lord,
We
my
will
lord,
see
let
it.
it be demolished after 6 months, not after
We will
demolition.
see it, Mr. Mandal. We will
Only
see if
a stop
requires
work
any
notice, my
urgency
lord,
or
so that
not.
I can live at my property properly, my lord. My life is in danger, my lord. That
Your
is the
life
only
is not in
difficulty.
danger.
My
We'll
lord,
see.
I will show
Mr.
you, lord.
Mandal, you have
Yes.
made your submission. I
My
have
lord,
heard
kindly,
you.
my lord.
I'll see it.
My lord, deeply obliged, your lordship. Deeply obliged. Deeply obliged.
Take the slip. Yes, call out the list.
My lord, may I have a lordship kindly, my lord, to mention item number 27 of today's list, my lord. My lord,
Yes.
my lord,
Matter will come. What is the urgency?
urgency is this, my lord. My lord, unauthorized construction is going on.
Very good.
Up
Let
the
it go on.
My lord, up on the roof, my lord.
Let them build more.
Or 25 years old building, my lord.
Very good. It will be demolished in accordance with law. All unauthorized construction will go.
My lord,
Let
very
your
good.
matter come up.
My lord, matter was mentioned several
Sir.
times. Sorry, my lord.
Can't be heard. Yes.
Item number 1 also I
Yes.
Item number 1.
I am appearing on behalf of state respondents.
Yes, you were saying some more people are joining you. What happened?
Yes. We have already filed for the P and file.
Where is it?
P, 4 and 5. Vakalatnam already filed. I have the.
So you'll move an application. Have you moved an application on behalf of the? So move an.
We have been making.
Oh, sir, so you will file an application or you won't file an application? Vakalatnama will do. What are you saying? Will you plead or the court will pass an order only on your vakalatnama? Will you make an application? Sir, whatever it is, you have to file an application for restoration. How will I pass an order on your vakalatnama?
Then Lordship may please to pass an order for the applicant number 4, and we shall file the.
Why should I pass separate orders? First 4 for 3, then 2. I mean, you expect the court even to tell you that you have to move an application.
Next week, course of the day I shall file.
Learned counsel of the petitioner seeks time to
No.
file restoration application on behalf of.
I am for the applicant number 4.
No.
And
Who are the other two people
3 and 5.
on behalf of applicant 3 and 5, who he states that have given a vakalatnama to him? Full stop. He states that he shall be filing appropriate application within a period of 2 weeks. Let this matter be listed after. September 18th. 18th September. 18th September.
No, kindly, Lordship, kindly. In course of the day I shall file the restoration application. Lordship may please to take the fact of.
How will you file an application in the course of the day? You have to get it notarized. You have to do so many.
Ready restoration application, Lordship.
So whatever it is, application is an application.
It hardly 30 minutes to complete the restoration application. In
He'll
course
have to
of the day.
start in accordance.
I must stop the
He has to give prior notice of, in the original side, he has to give prior notice of 48 hours or
It will be
at
filed.
least 4 clear days, otherwise 48 hours.
All right. 11th September.
I'm deeply obliged, but I am appearing on behalf of state.
My lord, I beg to appear with the petitioner in this matter. My lord, this is my application, your lordship, seeking, my lord, restoration of my writ petition as well as recalling of an order of June 26, 2025, my lord. My lord, the matter was dismissed for default, my lord, on the ground of non-appearance by the petitioner, my lord.
Yes.
My lord,
No objection.
I'm for the private respondent number 10.
court order may be passed.
Let this matter be restored and take down. There's an application filed by the petitioner. There's an application filed by the petitioner for restoration of the writ petition to its original position. Full stop. None had appeared for the petitioner, and hence The matter was dismissed for non-prosecution on 26/6/2025, full stop. For the reasons stated in the application and the concession granted by the respondent KMC, your opinion, respondent KMC, you have any objection?
I am for the private.
Any objection on restoration and by the private respondent? The present application is allowed. Writ petition is restored to its original position. Matter original position whenever the matter will come.
As you lordship. My lord is keeping in, fixing any date, your lordship. Grateful.
My lord, I am for the Kolkata Municipal Corporation, my lord. On the last occasion, your lordship has directed for exchange of affidavits. My lord, I am at fault. I am yet to prepare my opposition. I am praying for extension of time to file my opposition.
Yes. Yes. You want to file your affidavit? The learned counsel for the respondent Calcutta Municipal Corporation seeks and is granted further time of
2 weeks.
2 weeks to file their affidavit in opposition, right?
Yes, ma'am.
Affidavit in opposition. A reply thereto, if any, may be filed 2 weeks thereafter, full stop. Learned counsel for the private newly added respondent trust. Which trust is this? Pratap Chandra Mazumdar Memorial Trust, right? Respond number, your respond number? Respond number 5. Seeks and is granted 4 weeks time to file his affidavit in opposition. Reply to the same, if any, within 2 weeks thereafter. List after 8 weeks. This will go after vacation. 6th
Of November.
6th of November.
Great.
Four blood,
Petitioner is not there in this matter, right? Item 2, none for the petition. लिख देना उसमें आपा. None for the petitioner. पहला वाला जो item है, nobody is for the petitioner, none for the petitioner. None appears
Item
for the
number-
petitioner.
None for the.
हाँ, जो भी पहला. Number 3. Yes.
but item number 4, my lord, I appear for the petitioner in this matter. But
for the
I have
pres-
the instructions not to press this application any further. I have received the instructions. my lord.
So I'm for the private respondents.
Learned counsel for the petitioner seeks to.
My lord, pursuant to your lordship's direction, my lord, I am for the corporation. Your lordship directed me to file a report. Here is my report, your lordship.
You're not pressing the
No,
writ
I'm not
petition.
pressing it.
Learned counsel for the petitioner seeks to withdraw the present writ petition. The same is dismissed as withdrawn.
My report may be, my lord. Please.
The lordship will keep
पहले
the-
लिख देना. Learned counsel for the respondent Calcutta Municipal Corporation has filed a report by way of an affidavit. The same is taken on record. Full stop. उसके बाद आप लिखना. The learned counsel for the
my lord
petitioner
will keep the instructions on.
has handed over, learned counsel for the petitioner has handed over a copy of the instruction which he has received from his client not to
Instruction.
not to contest the present writ petition. Full stop. In view of such instruction, learned counsel for the petitioner seeks to withdraw the present copy of the instruction is taken on record. उसके बाद कर लेना. In view of such instruction, learned counsel for the petitioner seeks to withdraw the present writ petition. The present writ petition is dismissed as withdrawn. ये Another-
Item number 5 and 6.
My lord, I am for the writ petitioner.
But there is a direction for filing affidavits. There is a direction for filing affidavits, my lord.
Yes,
Well, it is under preparation, but it has not yet been affirmed, my lord. If your lordship, my lord, please, my lord, I am paying, my lord. If your lordship grants me, my lord, 2 weeks time more, my lord, to cover two index, my lord, 2 petitions.
My lord,
yes. Yes. Oh, this is, we will see that.
now, my lord, kindly see the last order.
So let
Of my
them
lord.
file.
No,
that-
I know
My
the
lord, I am
order.
coming to that, my lord. Today, the matter was due to appear
Yes,
for hearing, as per your
Yes.
lordship's order.
yes,
In the meantime, my lord, they could not file their affidavit.
yes.
They are praying for time for affidavit. That's all right.
Yes.
No, that is nothing. Now, my lord, in the meantime,
Yes,
the corporation has managed to have the applications filed by a third party.
I am
On that day, very day, your lordship did not allow them to say anything with regard to addition of party. Your lordship kindly remember, they tried to intervene on
we will
this
see
matter of
that.
heart.
sir.
that
We
will
will-
be
Everybody
considered
has
by
a
the
right to be heard
whether-
before the
whether
court.
allow-
My lord,
will
yes.
be allowed or
We
not.
will see
Let
that.
the application be taken up,
We will see that. Let the report.
or my lord, it may be taken up with the final hearing,
At the
as
time
your
of the
lordship
hearing.
wishes.
Yes, learned
Let it
counsel
come for
the
hearing, lord.
Respondent, Calcutta Municipal Corporation. Unnecessary submissions. Calcutta Municipal Corporation, Mr. Ghosh prays for further time to file his affidavit in opposition. Full stop. Prays for 2 weeks. Further time of 2 weeks to file his affidavit in opposition. Full stop. The same is granted. Reply to the same, if any, within 2 weeks thereafter. List
My lord, 1 week, my lord. 1 week will do for reply. For reply, 1 week, my lord.
1 week. Reply, if any, within 1 week thereafter. List after 6 weeks. 6 weeks कब होगा?
My lord, let it be after 4 weeks, my lord. My lord, plan has been cancelled. Day to day, we are incurring loss. We are spending money for rehabilitation of the owners and their tenant.
6th November. The same order in item.
Next time.
Same.
Also, your
Yes,
taking
my lord.
time.
Both are being hard
Same
together.
order. 5 weeks. Combined order. Last time I combined the order. Is it a combined order? Yes, it is a combined.
I beg to appear for the petitioner in matter.
Yes.
I will recall that, if you remember rightly, my lord, the KMC has raised a demand that is appearing at page 51 of the writ petition, my lord. Raised a demand and then asked me to file an objection within a time frame. I did the same within the time frame. Before I could have done that, they did not respond to my objection. Rather that before they could have received my objection, they have uploaded they have go with their demand. There is so my representation is there at page 54, another is at page 52. Both the representatives have been unattended. Last time they seek time to take instruction. Now,
Yes, Mr.
Taken instruction. There are 2 issues that there. This is well, the 51 says about the proposed annual valuation under unit area assessment.
No, but are you ready to decide his representation? Whatever you have done, you have done.
Oh, yes, that there is a difficulty, but only I'm also
What today his prayer is only for representation.
Mild.
Alright, the petitioner has preferred the present writ petition. Agreed by the petitioner has preferred the present writ petition.
52, 50, 44.
If I'm fast, you tell me.
52,
I'll
44.
slow down. The petitioner has preferred the present writ petition. Agreed by the inaction of the respondent corporation. in not considering the petitioner's representation dated 25/3/2025, seeking reassessment of his property. Property situated at first floor, 28/3A, Convent Road, Calcutta. Your representation is 23rd.
Page 44, my lord, kindly see once.
44, with regard to 44, I have my lord, some submissions because he has included regarding the area certain amount. Because so far as that amount is concerned, my lord, the earlier division up to the division bench, he has lost the case. Therefore, whatever the amount is there, my lord, so far as that can be only, my lord, is consideration. The assessment period, my lord, under unit area assessment, that may be taken into consideration that he has
At the time of passing the order in the representation, you can always say that.
There is another representation at the 62 also.
So and so, learned counsel, the respondent, municipality, corporation submits that they are ready and willing to consider petitioner.
On instruction, your lordship.
On instruction, Mr. Ghosh, on instruction submits that the corporation is ready and willing to consider petitioner's representation dated 25/3/2025. Full stop. Learned counsel for the petitioner states that he shall be satisfied if the same is decided within a time-bound manner. Full stop. In view thereof, comma, the present writ petition is disposed of with a direction to consider and dispose of petitioner's representation dated 25/3/2025 within a period of
24/3.
within a period of 4 weeks
24th month,
from the date of communication of this order,
42,
comma,
44.
strictly in accordance with law, comma, after affording an opportunity of personal hearing to the petitioner, comma, by way of a speaking order, full stop. With the above direction, the present writ petition is disposed.
I'm sorry, my lord, the representation dated 24th March, goes down 25th March.
24th March, 23rd, 24th.
I'm deeply obliged. And great.
Lordship, I beg to appear on behalf of the petitioner. Our Lordship was kind enough to hear this matter on the previous occasion. My lord, what happened in our writ application, the order of Thika controller was not there. Lordship allowed us, my lord, to bring this particular document. My lord, we have, my lord, prepared a supplementary affidavit subject to leave of this honorable court. My lord, I can.
Give a copy of the
I'm giving it. I'm giving. সবাইকে দিয়েছি, স্টেটকে দিয়েছেন? State for the first time, বোধহয় আজকে appear করছেন, আচ্ছা আচ্ছা।
It is a concern.
Concern, the last occasion not appeared.
The state is
They have
concerned.
not shown their concern,
They should go to the
like you.
tenancy tribunal.
No, tenancy tribunal not.
Yes, yes.
আছে, দেখা কপি আছে? Supplementary extra কপি আছে?
বোর্ডে এমনি নিয়ে নেবে পাকা পাকা।
তাহলে page 14, my lord, lordship kindly see order dated 22nd 6/1998. My lord, here, my lord, I am reading
The main writ petition or the supplementary affidavit? What are you?
supplementary affidavit. My lord, pursuant to the direction, my lord, permission granted by this honorable court. Page 14 may kindly be looked in.
Yes.
My lord, the instant case was taken up for hearing in terms of so and so, my lord, regarding illegal transfer of Thika land. Next para, notices of hearing were also served upon the transferor, Sheikh Majahar Ali, son of so and so. The transfer is Sri Horigopal Das, son of late Amullocharan Das of so and so, my lord, the Bharatias, and the Bharatias, Sri Hori Das, turn to next page, my lord, Dilip Kumar Das and others. Hearing took place on so and so date when the transferees and Bharatias appeared, but none reported on behalf of the transferor. This spot inquiry also duly held by the concerned regional Tika tenancy office, and the report received from the officer in charge, my lord, and then, my lord, deposition made of the both side, Xerox copy of the sale deed, assessment roll of CMC, report, and thereafter, my lord, next paragraph of the regional office, it appears that the disputed land is a Bosti land, which comes under the provision of CTT Act 1981. And the transfer of the said property stand on the premises by way of sale deed has taken place in violation of section 6(3) of the, my lord, the Tika Tenancy Act 1981 and its amendment 1993. Hence, it is ordered that the structure standing on the premises, so and so, my lord, turn to next page. Stand vested to the state of West Bengal, free from all encumbrances, with effect from the date of this order. My lord, the date of this order at the bottom, 22nd June 1998. Lordship got it. The date, my lord, 22nd June 1998. Then, my lord, turn to my lord, kindly come to, my lord, being aggrieved by and dissatisfied with this order, my lord, I being being dissatisfied this order, annexure P10. Here, my lord, I have
Information slip.
then, my lord, kindly see, my lord. My lord, we have preferred, my lord, one civil suit, and civil suit was a decreed ex parte. Civil suit was a decreed ex parte. And then, lordship, kindly come to page 26. Here, the state authority preferred one appeal. Against that, my lord, shoot. Title suit number 38 of 2002. Petition 38 order. Petition petition. My lord, kindly see here the state authority preferred one appeal before the, my lord, the appropriate forum. And, my lord, the appropriate forum, my lord, was of the opinion. My lord, kindly see, my lord, remarks column.
Which page, sir? Which page?
Page 26. Annexure P12.
Information
This is information slip.
Preferred against the Tika controller's order.
Yes.
My lord, initially, my lord, we have preferred, my lord, one title suit that was decreed, and thereafter state authority preferred appeal. Appeal, my lord, while replying information, my lord, our query for supply of information, my lord, it appears from remarks column, the miss case being number so and so is dismissed on, my lord, in the year 2008, possibly, my lord. My lord, it was dismissed, my lord. State can, my lord, challenge this particular information slip, and, my lord, if any document is lying with them. My lord, then, my lord, lordship, I am drawing lordship attention. That was, I had drawn, my lord, lordship attention, page 18 of this, my lord, supplementary affidavit, where, my lord, the shoot was decreed ex parte. And
No jurisdiction.
lordship will find from the ordering portion, page 21. Ordering portion, my lord. Before that, my lord, I am drawing lordship attention, page 19. Second paragraph, lordship will find the date of order, 22nd June 1998, which was the order of the Tika controller.
Do you have made the Tika controller a party here?
Yes, my lord. My learned friend is appearing on behalf of them. Now, my lord, page 21, plaintiff do get a decree, first, second, third, fourth paragraph, for declaration that the plaintiff is lawful and absolute owner of the suit property and well seized and possessed of the suit property as absolute owner. Then, my lord, the appeal preferred by the state authority, which has been dismissed. My lord, my name was in the record of Kolkata Municipal Corporation. Now they have deleted my name from the assessment book. Taking a particular plea, some other matter. My lord, there are number of tenants. I have filed cases against them for eviction from the tenanted premises. My lord, that was dismissed, not allowed, anything may happen. Now the tenants and occupiers are there because I did not get any success so far the other civil suit of evictions are concerned. Now, my lord, in the event this building is constructed, I have to accommodate all the tenants and occupier in the new building. So, my lord, here our humble submission before this honorable court, the decree of the civil court is finality. It has assumed the character of finality. There was one challenge which was unsuccessful, as a result of which this finality which it attains cannot be questioned by the Kolkata Municipal Corporation, since they are not the authority to, my lord, put any question in their mind. They should kept it in their mind, not to publish it, not to write it. And this writing has taken place, as a result of which that particular order is impugned, and I am before this honorable court. This is my humble submission, my lord.
Yes, Mr. Ghosh.
So far as we are concerned, my lord, we have, my lord, recorded an order that is under challenge by my lord, my understanding, my lord. The challenge, my lord, we have said, my lord, that is the order which was passed by the Thika controller as far back as on, my lord, 22nd of June 1998. And on that basis, my lord, we have recorded that the recorded owner should be the state of West Bengal, represented by the controller Thika tenancy.
Yes.
And the other persons who are on record, the occupier, those persons' names are recorded. If you looks at the details consideration at page 46 of the writ petition, this order is under challenge. Well, this is really an issue in respect of the order passed by the Thika controller. If the Thika controller says about that it's not a Thika property, or it has not been vested, property has not been vested.
So what happened to the order of the Thika controller?
They have
It is
challenged in the suit court, and suit court, my lord, set aside.
You have not challenged this order.
Yes, my lord. I am showing. Once again, I am showing, my lord. Lordship, kindly come to, my lord, page number 18. Kindly come to page number 19, my lord. For a moment.
Just a minute.
For a moment, my lord. Kindly come to page 19 of the supplementary affidavit. Lordship will find in the second paragraph. My lord, last three line, defendant number 2 also declared that the structure standing on the premises number so and so stand vacated, vested, not vacated, to the state of West Bengal, free from all encumbrances, dated, my lord, 22nd June 1998. Lordship, kindly see, my lord, the order of the, kindly see, my lord, the order of, my lord, Thika controller, page 17. Page 17, that is the order of 22nd June 1998 by the Thika controller. And last few line, my lord, used by the Thika controller has been used by the tight suit code, my lord.
Mr. Chakravarti, can you go a little slow?
Lordship?
Just go a little slow.
Look,
I'm not that quick. I take time to understand.
my lord, because of, my lord, possibly, my lord, in my some my lord,
You
complication.
go very fast. Just go a little slow.
True, my
Yes, tell me
True,
what
my
are you showing? I'm not as intelligent as you are that I will catch up so fast. I take time.
My lord, not,
Let us go slow.
not to be thrashed in this manner. This is
No,
my
Mr.
practice.
Chakravarti, you go so
True,
fast.
my lord.
You go very fast.
Everyone knows, my lord,
Take your time.
what lordship is than what I am. My lord, no problem.
Tell me, page 19, you are
Page
reading.
19, second paragraph.
Yes.
Lordship will see last three line, my lord.
Yes.
Defendant number 2 also declared that the structure standing on the premises number so and so stand vested instead of vacate, my lord, it should be vested to the state of West Bengal, free from all encumbrances, with effect from 22nd June 1998. That is the date of the order of the Thika controller. Then, my lord, see, my lord, the next line, that the Thika controller has no jurisdiction to decide the right, title, interest of the party, and also Thika controller has no jurisdiction to decide whether the property in dispute all come within the jurisdiction of the Thika controller. So I have challenged it, decreed, they have preferred appeal, dismissed. That being the situation. And, my lord, my learned friend raising one question, why not LRTT?
No.
No, in the year 2005, that particular act included within the specified act of LRTT. Yes, certainly. After looking everything, we are making this submission. Not possibly. আচ্ছা ঠিক আছে আছে LRTT act আছে No, but I'm showing.
Yes.
না আপনি এটা দিন আমাকে LRTT act দিন. At that point of time, there was no LRTT. Subsequently, in the year 2005, this particular land included, I am showing. Lordship will find, my lord, from the specified act of 2R, specified act of 2R,
Yes, yes, Mr. Just let him finish. Yes, Mr. Chakravarti.
that I am showing. My lord, the Thika tenancy, my lord, I am showing, my lord, the specified act of Thika, my lord, the West Bengal Land Reforms and Tenancy Tribunal, West Bengal Estate Acquisition Act, West Bengal Land Reform Act, West Bengal Restoration of Alienated Land Act, my lord, the West Bengal Acquisition of the Homestead Act, then five, my lord, I'm coming, my lord. Thika control, এই বইটা নয় তো মনে হচ্ছে। West Bengal, then my lord, 7, West Bengal Thika Tenancy Acquisition and Regulation Act, 2001. এই বইটা, my lord, only from, my lord, from 2000, no, 5, 5, West Bengal Thika Tenancy, my lord, kindly see 5, and at the bottom, inserted by West Bengal Land Reform and Tenancy Tribunal Act 2005, with effect from 1/3/2005. My lord, this is specified act, my lord, R, Roman 5, and at the bottom footnote. And at that point of time, my lord, the civil code has the jurisdiction. Everyone knows it, my lord. Number of judgments are also there.
You are reading 2R, right?
Yes, my lord. R, lordship, specified act. Judgment din na. Jyotirmoy Bhattacharya judgment din. আমার এই নোট কা বইটা আনতে পারে। There.
So you are relying on the West Bengal Thika Tenancy Acquisition and Regulation
Yes, my lord.
Act 2001. So if you were aggrieved by the order passed by the Thika controller, you should have gone before the tribunal?
No, at that point of time, it was civil code, my lord. And as a result of which, my learned friend, without raising that question, preferred appeal, which was dismissed. At that point of time, had it been within the control of, my lord, the Land Tenancy Tribunal, my learned friend would have, my lord, would have taken appropriate steps. Instead of that, he had challenged it before the civil court, my lord, in a, my lord, appeal, challenging the order of, my lord, passed by the court below, lowest rank of judiciary.
The preferring appeal does not confer any jurisdiction.
If the Honorable Court directs me, my lord, to bring number of judgment to show, at that point of time, it was the, my lord, the civil court. Only subsequently act amended, and Thika controller has given right to decide the question which property.
Ex parte order, they were not even there. You have not
Preferred appeal.
Did you prefer appeal?
Yes.
Let him complete, my lord. So far as
Yes, you finish your argument.
Yes, my
lord, so far as
Just a minute, let him finish.
So, my lord, this is my humble submission. The order of the civil court cannot be interfered and intervened by the Kolkata Municipal Corporation. Their duty, my lord, to put name of someone who is the person responsible to pay taxes, person liable to pay taxes. So, my lord, they have exceeded its jurisdiction and passed this order. We are seeking intervention of this honorable court. My lord, this is my humble submission.
Yes. Yes.
so far as Thika acts are concerned, my lord, we are referring to 2001 Act. Now, my lord, the suit was filed prior to that. Was not filed prior to that. Now,
Suit is filed. When is the suit filed? The suit is filed in the year 2002. After that, not prior.
Exercise its jurisdiction under the provision of Calcutta Thika Tenancy Act 1981. It's not under 2001 Act. Now, I want to establish before your lordship that West Bengal Land Reforms Tenancy Tribunal Act 1997 was promulgated, and the tribunal was established by the notification on 12th of August 1998. And during the year when the order was passed, the West Bengal Thika Tenancy Acquisition and Regulation Act 1981, that is the prior act, was a specified act. Let me hand over the book. They
contending inter alia from this court that 2001 Act. They are showing that is a specified act and it was operating on and from 2005. But prior to that, my lord, 1981 Act was enforced, and that 81 Act was also a specified act. Apart from that, my lord, section power of the civil court, exclusion of jurisdiction of court, is specified in section 8 of this particular act. I will but not that act, my lord. That is the latter amended provision, my lord. I will hand over this book, my lord. On and from the date of which the jurisdiction, power, and authority become exercisable under this act by tribunal, high court, except where the court exercises writ jurisdiction under Article 27 of the Constitution by division bench or any civil court, except the Supreme Court, shall not entertain any proceeding or application or exercise any jurisdiction, power, or authority in relation to adjudication or trial of dispute or application relating to land forms or any other concern thereafter or incidental thereto or any other matter under the provision of the specified act. I hand over the book, my lord. It has been specified act in definition, a specified act. And
No, but what steps did you take to protect your property? You are saying it's a Thika property.
The same was recorded in the Thika controller's office.
But why you have not filed a complaint before the corporation for getting the,
Clear, my lord. It is in my name. Clear possessing the property.
who has the complaint on which the corporation has acted
They have
is a
complained.
complaint filed by one of the tenants, I believe. That's right, Mr. Ghosh?
The land has vested before the state. But the provision of 1981 Act provides that the land will vest before the state and we will become direct tenant under the state. So we are liable to make payment of the rent before the state of West Bengal and make municipal taxes before the corporation. But
Yes.
there is no question of placing any objection with regard to the state. Apart from that, my lord, what they have not disclosed before your lordship is this. There was initially a suit by Hari Gopal Das, my lord, the petitioner hearing, my lord. That was dismissed on the same ground that the Thika controller has passed an order, my lord. They preferred an appeal, and the same appeal was disposed of comparing with the judgment passed by the trial court, my lord. And now this is the judgment, my lord. May I indicate? And this court observed that the Thika controller has already passed an order. Plaintiff hearing was the same, the petitioner here. Your lordship will find from bottom of page 4, my lord. Yes, my lord. Here, my option, the respondent defendant. That means my client. My lord.
Yes.
The respondent defendant contested the suit by filing written statement wherein he denied all the material allegations leveled against him and further stated that he was never a tenant under the appellant plaintiff. And the appellant plaintiff, next paper, and the appellant plaintiff is not owner of the suit premises as the same is Thika tenanted property which has been vested to the state of West Bengal. Subsequently, one portion challenging the maintainability, one petition challenging the maintainability of the suit was filed before the lower court, and after hearing the same, the learned lower court dismissed the suit on contest with an observation that the suit is not maintainable in law. It was their suit. As per the memo of appeal is concerned, the appellant plaintiff seems to be aggrieved by the lower court decision for dismissal of the suit while disposing of the maintainability point. Learned counsel appearing on behalf of the appellant plaintiff orally stated that there is some discrepancy as regards the dates of the lower court record. On perusal of the lower court record, by the order dated 32, dated 8/2002, it appears that the date was fixed on 9/9/2002 for ex parte hearing, whereas in the middle portion of the said order, it also appears the matter has been fixed on 2/4/2002 for ex parte hearing. Be that as it may, the last paragraph, my lord, on the perusal of the order dated, order number 32 dated 2002, it goes to show that in the portion of the order, the date was already fixed on 2002 for ex parte hearing. in spite of which the last portion may be due to some inadvertence, the date has been mentioned in 9/9/2000. On perusal, the third paragraph of page 6 deals with the merit. Now let us come to the merit of the case. As per the plaintiff, the appellant plaintiff is the owner of the premises and the responding defendant is the tenant under him. The claim of the appellant plaintiff is that he has purchased the premises of Sheikh Ghulam and other who happens to be the legal heirs of Sheikh Bashir Ali for a consideration of such and such on 23rd of December 1987 by registered date. On perusal of the materials on record, it goes to show that the hearing was taken by the controller of Calcutta Department in court motion. On perusal of the materials on record, it goes to show that the hearing was taken by the controller of Calcutta Department in terms of N and LR Department, Government of West Bengal by memo number such, dated 8/8/97, regarding illegal transfer of land at 5A/8/9, Parmari Road, Calcutta. From the said order dated 22nd of June 98, it also reveals that the notices of hearing was duly served upon the transferee Sheikh Mazahar Ali, son of Sheikh Bashir Ali and others, and the transferee Harigopal Das, and also upon the Bharatia. The hearing took place on 11/2/98 and 25/98, when the transferee and the Bharatias appeared, but the transferor failed to appear before the controller. The report also reveals that departmental inquiry. Inquiry was duly held by the concerned regional departmental office, and report was also received from the office in charge. Thereafter, on the basis of the report deposition and from other records, it was held that the controller of Calcutta Department said the land is a Basti land, which comes under the provision of Calcutta Department Act 81, and the transfer of the state property by way of the sale it was placed in violation of section 3 of the Calcutta Department Act 81 and its amendment 1993. According to the structure, standing recorded in here, order of the Tika controller and thereafter concludes. Now, in the memo of the appellant plaintiff has pointed out that the appellant plaintiff has already filed title suit number such and such against state of West Bengal, in which we were not a party. And the controller of Tika is praying for declaration that the suit property is not a Tika tenanted property. Well, that suit, what he is glad upon, has been recorded and taken into consideration. And the controller appellant plaintiff is the owner of the same. Here, filing of any such suit, if the facto does not change the present status of the appellant plaintiff. The observation and the language of the order passed by the controller department is absolutely clear. The observation made by the lower court that in terms of the order passed by the controller, the suit is not maintainable, does not seem to suffer from any sort of irregularity. Well, in view of the fact this was passed by the appeal court, by the now, may I just reply upon again this book, my lord. During the year 1998, when the conductor passed the order, premises tenancy land of tenancy tribunal was already existing. This 1981 Act is a specified act. They ought to have preferred an appeal or challenge this order. Rightly or wrongly, the controller has passed an order. The civil court had no jurisdiction. So, they ought to have challenged this order before the Land Reforms Tenancy Tribunal. What they are indicating, that is 2001 Act. This is a subsequent act. Well, during the year 2001, my lord, the 1981 Act was repealed and the new Act, 2001 Act, came into force. My lord, earlier it was Calcutta Tenancy Acquisition and Regulation Act. Subsequently, it was has been promulgated as West Bengal Tenancy Acquisition and Regulation Act 2001.
When was this order passed by the Tika controller? 87. Thank you.
And the tribunal was established on 12th of August 1998. And the act came before the government. Act was received on 12th of December 1997. This is the act. May I hand over this earlier act?
You file your reply. File your reply.
Objection.
Objection.
Details reply.
We will let everything come on record, then we'll pass an order.
Only by your, may I be permitted, my lord, to refer section 12 and 13?
So let them file. It
Yes,
is,
yes,
Mr.
we'll answer-
Chakravarti,
we'll
it is
answer.
not as simple as you make out to be.
We'll answer it, my lord. At that point of time,
By this honorable court.
There is, these are disputed question of fact.
we'll answer it, my lord. 12 and 13 of the 1981 says it should be in the civil court.
But A. Chandrakumar's judgment comes into play, madam.
But judicial review, I am seizing that opportunity for judicial
A.
review.
Chandrakumar's judgment specifically provides that since the specified act has been passed, the civil court and the writ court ceases to operate its jurisdiction.
So, my lord, for that reason, my lord, lordship has to go through the section 12 and 13 of the 1981 Act.
We will see that. Take down. Learned counsel for the petitioner has filed a supplementary affidavit as per the direction of this court by an order dated 17 July 2025. The same is taken on record. Full stop. Learned counsel for the respondent, Calcutta Municipal Corporation, as well as the UR, respond number 8. Respond number 8.
I am appearing on behalf of the respondent.
Respond number 8 and 9. Respond number 8 as well as respond number 9 to 13 seeks and is granted 4 weeks time to file their affidavit in opposition. Affidavit in opposition, reply to the same if any within 2 weeks thereafter. All the respondent, KMC also. क्या लिखा है? 9 to 13, seeks and is granted 4 weeks time to file their affidavit term. A reply to the same if any within 2 weeks thereafter, list after 8 weeks.
In a particular date, my lord, in a particular date.
Yes. 8 weeks.
8 weeks.
November.
Deeply obliged.
Give back the book.
May I take back my book?
Yes, yes.
I waited.
Item number 9, before the petition, Lordship has on the last occasion directed the Kolkata Municipal Corporation to, yes, the report, Lordship, I believe the Lordship has directed them to file a report and we were supposed to file an exception. But my lord, the hearing, Lordship, they have fixed a hearing, Lordship, I'm instructed on 18th, so I'm sure the report has not come.
Hearing is fixed on 18th.
He keeps it after 3-4 weeks, my lord, so.
Already fixed on 18th, and as per our report submitted before your lordships here on the last occasion.
Lordship has perused the report and
Immediately by the next returnable date, we will come with a specific.
Learned counsel for the respondent corporation seeks and is granted further time of, how much time, Mr. Banerjee? Further time?
Any day in the month of November, but automatically, but.
No.
You want it in November?
Any day, otherwise in the next month.
Further time of 2 weeks to file his report by way of an affidavit. Exception, if any, be filed within 1 week thereafter, list after 4 weeks? After.
Lordship.
Automatically, obviously.
তুমি কে?
আচ্ছা ঠিক আছে আমি আমাকে নাম্বারটা দিয়ে দিই।
All of you assume things.
নাম্বারটা দিই। After
Who are you?
Yes.
কত তারিখে আসবে?
What is the date which you have given?
I appear on behalf of the interviewer in this matter. Mr. Jishan, please.
Milord, I am appearing for the intervener, Milord. I have an application which is before your lordship, Milord, for intervention. My name is recorded, Milord, as the person liable to pay tax. Somebody wants it to be removed, but he's not made me a party, which is why, Milord, I've sought for intervention.
Your Lordship, this is my petition for reinstatement of my name in the municipal records. Your Lordship, the KMC had been directed to file an affidavit in opposition, which was served upon us a little belatedly. Lordship, may I kindly hand over the affidavit in reply, which we've already served to the KMC? Lordship, we are being led by Mr. Joydeep Kaur in this matter. He's on legs before, he's come to court, Your
Yes.
Lordship. Yes, he's come to court. He's on legs before another court. May I humbly pray for a short passover, Your Lordship?
No, we'll
My
have
lord,
it
may
some
I
other-
request for Tuesday, my lord, in that case, my lord?
Affidavit in opposition filed by the respondent Calcutta Municipal Corporation is taken on record. Reply to the same filed by the petitioner is also taken on record. Let this matter be listed on 11th September.
Grateful, my lord.
Grateful, Your Lordship.
It needs to also have the intervention application to appear in the
It
natural
will-
course of things.
Will
Grateful,
appear.
grateful.
If you have filed it, it will appear.
Yes,
We'll see whether we'll allow or not.
yes. Grateful to you.
Grateful. Your
I appear for one of the respondents.
Your Lordship, I'm appearing on behalf of the petitioner.
Kindly seize your Lordship's previous order.
I am here about the Heritage Commission.
Your Lord,
Or after the Lordship.
Yes, madam.
Your Lordship, there was a direction to file a report.
Yes.
So their report has not been served upon us yet.
Second last page.
Thank you.
Corporation by way of an affidavit if they corporation.
Mr. Ghosh, where is Mr. Ghosh?
The last petition, now they go. Possibly by
Learned counsel for the respondent corporation takes and is granted further time of 2 weeks to comply with the order dated 17th July 2025. To comply with the order dated 17 and to file a report in the form of an affidavit, comma exception to the report if any be filed within 1 week thereafter, list after #21st, 4 weeks would be 18th September.
Well, one thing, my lord, so for point of maintainability, whether I don't know.
Yes, you have said that he has no authority because he is no longer the tenant.
Apart from that,
You have also taken the same stand.
my lord, what as the Heritage Commission is concerned, on the last occasion I submitted.
Heritage Commission, we have already seen it's not a heritage property.
Not a heritage property. Well, I have
My
seen all
lord,
the list.
no
total
petition.
list.
Last time also this clarification.
And not only that, in paragraph 4 of the petition, he has specifically averred that it is a Heritage Commission and he is produced the documents so far as the property is in Heritage Commission.
Yes.
But this is the entire list of the Heritage Commission of which the buildings are listed as heritage.
Yes.
Is suffering a degree of evictions for illegal occupations. That is why he tried to create a pressure. Nothing more, nothing less. He has got a legal right to stay over there.
We'll see that.
Oh, great.
We had directed the KMC to inspect the property and file a report stating if there are any unauthorized construction.
Get
Iska? Acha. Learned counsel for the respondent, Calcutta Municipal Corporation, seeks and is granted. KMC to file a report in terms of the order dated 17 July 2025, exception if any within 1 week or 2 weeks qualifier within 1 week thereafter. This 18th.
Yes, may I leave, my lord?
Yes.
My lord, item number 12, I beg to appear for the petitioner, my lord.
Yes.
My lord, the matter is hereby when the petitioner has challenged the order passed by the hearing officer, assessment hearing officer, my lord. The petitioner is the owner of the property, my lord, and petitioner has been granted with a sanctioned building plan to reconstruct a residential building, my lord.
Yes.
Thereafter, my lord, in terms of section 184, the respondent has issued us
Why don't you file an appeal before the tribunal? Why are
my
you
lord,
here?
they have not proceeded properly, and the order
Whatever
is
it is.
triptych, my lord, in nature. And there is no unreason. They did not even take my objection.
Go before the tribunal. Why should I entertain this?
As per section 189, there is a tribunal, my lord.
Go before the tribunal.
Well, my lord, then kindly grant me liberty so that I can approach the tribunal, my lord.
Period has already expired. If your
That
lordship grants
because,
the
my lord, I
period,
have
I
filed
cannot
this application.
You have to move an application before the tribunal. Section 5 application, you move it before the tribunal will decide it.
Your lordship, should I leave
And
the
state
petition?
you have chosen a wrong remedy, you came here, it will be decided.
Application's time has already expired.
At least, my lord, grant me that liberty so that I can take a section 14's plea of limitation act before the tribunal, my lord.
You can always do that. You don't need any liberty for that.
Section 5.
The petitioner, comma, by way of the present writ petition, comma, challenges the order dated 24/12/2024, comma, passed by the hearing officer, comma, whereby the annual valuation of the premises number 147, comma, Park Street, comma, under SSC number 110611801075. Was fixed at rupees 52,026,010. 52 lakhs 26,010 with effect from the first quarter of 2017-18 under the unit area assessment. Second, 72 lakhs 20,820 with effect from first quarter of 2019-20 under the unit area assessment. Third, 77 lakhs 75,400 with respect to fourth quarter 2021 and separate assessment of roof of the premises, comma, proposing an annual valuation rate of 9 lakhs 99,130 with effect from first quarter of 2019-20 under the unit area assessment. Full stop. The case of the petitioner that she is the lawful owner of the subject premises, comma, having purchased the same, she had constructed multi-storied buildings comprising of ground plus 6 floors, basement plus ground plus 6 floors. Full stop. The completion certificate has still not been. You don't have the OC, right? Occupation certificate, they have not got. Completion, you have not received the completion certificate.
No, my lord, we have not
The
received
completion certificate is still awaited. Full stop. On 3/10/2024, comma, the petitioner received a notice proposing the aforementioned revisions in assessment. Full stop. Hearing was conducted thereafter and by the impugn order dated 24/12/2024, comma, the proposed assessment was confirmed. The petitioner contends that although she participated in the hearing, no effective opportunity of hearing was granted to her. Full stop. It is further submitted that the request for the joint inspection of the property for its proper assessment of the area and parameters were requested, but the same were not acceded to by the municipal corporation. Full stop. The impugn order is an appealable order before the municipal assessment tribunal under the relevant provision of law. Full stop. Since an efficacious alternate remedy is available to the petitioner, this court is not inclined to exercise its discretionary jurisdiction under 226 of the Constitution of India. In view of the above, the present writ petition is disposed of with liberty to the petitioner to approach the municipal assessment tribunal in accordance with law. Accordingly, the present writ petition is dismissed.
Grateful, Lordship.
But I apply for the writ petitioner. But this pertains to, my lord, the petitioner's consideration for promotion to the rank of executive engineer from the rank of assistant engineer.
Executive engineer. Executive engineer from A to E, right?
A to E. Now, my lord, his name is shown below down below in the gradation list by non-reckoning of certain qualifications that he had attained. But if these qualifications are taken into consideration, then he will be reckoned as a person with a degree holder, as a degree holder candidate. If these are disregarded, then he will be not considered as a degree holder candidate.
So what is the length of service which a degree holder and non-degree holder need to have for promotion?
The residency period is minimum 3 to 5 years, depending on the ranks.
No, what is your RR?
RR, Kolkata Municipal Corporation has an eligibility in terms of qualification, and there is a as of today there are draft rules.
13 years, 5 years, degree holder, then you will go to the
Rule চাইছি।
The supernumerary post will only be created if it's been languishing for stagnation.
Page কত?
Qualification aspect was mentioned. Then whoever in a lower, even a lower position, in the SE cadre, he could be given the supernumerary A4 because of that terms and condition. That does not imply that he will be regular promotion. In the event of giving regular promotion, that he will be taken into consideration accordingly. That has been the question has raised supernumerary the date of joining to the post of supernumerary
Presentation, documentation.
to be considered taking part in the regular AE, that issue has been resolved by this honorable court after the division bench and then after the Supreme Court. Therefore, his position as in the AE by the assistant engineer civil, that position cannot be altered as it is in July 2021. Because he is concentrating about the 5th of July 2021, the gradation list. That gradation list, whatever way it is now, in toto, has been accepted by the division bench, finding no fault with that. We cannot touch it right now in any way.
That matter is not that where I was part of the division bench. No.
No, you also
There is one, yes.
You also yet this matter. My learned senior or someone my lord was for the meeting. You could not follow what is submitted virtual.
Yes, yes, sir.
Today the question is not entirely different.
You're asking for the amendment to the gradation list, right?
Your lordships can always modify this. But perpetually, I cannot be reckoned out of the zone of consideration.
We can always modify it subject to your
eligibility. Now, today, if your lordship's court find that these attainment of qualification cannot be disregarded by the KMC for the purpose of considering me as a candidate who has the degree qualification, then not I may be entitled to certain benefits in future in terms of eligibility as I may come in the zone of consideration. I may move up in the gradation list apropos this candidature being considered or this degree being considered. Now, please come to just a minute.
Yes.
Please come to paragraph 11
Paragraph 11.
at page 6.
Yes.
On 5/7/2021, the final gradation list for the post of assistant engineer had been prepared by clubbing degree and diploma holder under engineer service in the KMC as on later date of the last promotion to the post of executive engineer was published with a chief manager's letter of 12th of March 2021, wherein the name of the petitioner is at serial number 178 as his BTech civil degree and ME geotech degree was not clubbed or but it should be read as considered. If his BTech or civil degree and ME geotech degree was clubbed, then he would be at serial number 89 in the gradation list. Not why this is so, not the diploma holders have been a block placed below the degree holders. So not these qualifications, if these are considered, then I become a degree holder and I may move up the gradation list in terms of seniority. That's the sole issue to be decided.
Yes, Mr. Ghosh. You file your reply. Reply has to come before we decide this. Take down the petitioner, comma, by way of the present writ petition, comma, challenges the final gradation list. Which is that final gradation list is dated?
No, but 24th May 24 should be.
No.
24th
May 20.
May. 24th May is what you have stated, sir.
21 days left.
Why 24th May?
But there is a prayer C. I'm sorry, this is referred to as at paragraph 12 in page 7. Oh, very good. Not the 21. No, I'm sorry, 21.
What is the date, sir?
Not,
Yes, sir.
not prayer A, if you prayer B at page 16, if your lordship kindly considers. As to why the candidature of the petitioner for promotion.
That's all right, but which gradation list are you challenging dated?
Has to be the 21 gradation list.
5th July.
21.
5th July 2021. Pertaining to the post of Assistant Engineer Civil, comma, on the ground that his additional qualification of BTech and ME have not been taken into consideration. BTech Civil degree and ME Geotech bracket mein डाल देना. Degree have not been taken into consideration. It is further contended by the petitioner that despite being senior, he has been denied promotion to the post of executive engineer while his juniors have been promoted, comma, thereby subjecting him to arbitrary and discriminatory treatment. Full stop. Learned counsel for the respondent corporation, Mr. Ghosh, submits that the petitioner is not entitled for the said promotion. Full stop. He seeks and is granted 4 weeks time to file his
6 weeks. Many affidavits.
6 weeks.
But my learned friend said that it has already been filed up to the division bench.
6 weeks time to file his affidavit in opposition, reply to the same if any within 2 weeks thereafter, list after 8 weeks. Why maintainability? Why maintainability?
No. That has been outlawed by the dispute bench and up to the Supreme Court. Then this follow the issue because ultimately we are for
Till maintainability, he can always file a petition. Maintainability will not come into play then also.
So
Then it will only be that he is, in terms of the judgment passed by such and such, he is not entitled. Maintainability is always there. Maintainability, not in this. Give a date. Have you given a date? You are appearing for the first time. You are appearing for the first time here, not before me. You have appeared before me on the criminal side, but we give a date also. Give a date. Thirteen November.
If 14, my lord, before showing any paper, my lord, my humble submission is, my lord, I have purchased a property. It was mutated in the Kolkata Municipal Corporation. Then I obtained a sanctioned building plan from them. Suddenly I have received one notice from the Kolkata Municipal Corporation. It is a heritage property. Before granting, my lord, that sanctioned building plan, they did not consider it. Be that as it may, my lord. My lord, I wrote a letter addressed to them as to why this is, my lord, heritage property. My lord, they are not in the habit of replying. My lord, I had to prefer one writ application before this honorable court. Honorable court said this is within the four corner of the, my lord, the right to information. You have to supply it. Cannot take the plea of section 8. My lord, supplied. It seems from the supplied document, the Heritage Commission, my lord, not considered this property as heritage. My lord, in Heritage Commission, my lord, the number of KMC bosses are there, KMC personnel are there as a part of the Heritage Commission. They are the expert body, took this decision that this is not a heritage property. KMC is, my lord, they have a particular provision of Heritage Conservation Committee. Prior to introduction of Heritage Commission Act, there was certain provision in the municipality to protect the heritage. That is why Heritage Conservation Committee, that is still continuing. Now, my lord, the expert body is there on the one hand, this is not heritage property, and the KMC is standing on the way, not to allow me, my lord, to do construction. Lordship knows sanction building plan for 5 years. Additional, my lord, 5 years will be granted for renewal and revalidation. Now I am in a difficulty. My lord, I think, my lord, this is with the possibly, my lord, required one exchange of affidavit, my lord. The expert body is there, my lord. They are to, my lord, say as to why they are considering it not heritage. On the other hand, the KMC has to make a case why this is heritage. And myself is in a really in difficulty. Only thing I am asking, my lord, in the event this honorable court, my lord, thinks it fit and proper, this is not a heritage property, my plan is required to be revalidated.
That he will make a statement.
This is the problem. And one is West Bengal Heritage Commission Act 2001, and another is Kolkata Municipal Corporation Act 425 Heritage Conservation Committee. This particular property is not in the list of West Bengal Heritage Commission Act 2001. So heritage.
Then Calcutta can do nothing.
Yes, ma'am. Deeply obliged, deeply obliged. Special act, my lord.
They can do nothing about it.
Nothing. Only the Calcutta Municipal Corporation.
Conservation, whatever it is, they can do nothing. Conservation is only flowing from the right, which is by you.
Deeply obliged.
The commission. If you declare a property to be heritage, it is heritage, otherwise it is not heritage.
We declare only on the request.
Yes,
from
sir,
the
that's
public.
what. Yes. So this property is not a heritage property according to you. Yes, Mr. Ghosh. Where do you derive your power from?
Well, the power melody in melody in my statute.
You can't declare any property.
These issues have been decided by this court, my lord. Up to the division bench, there are several orders and judgments. He is really asking for delisting of the
What
property.
is the decision of the several orders passed by this court?
Regarding all the bunch
That
of,
do you have the power?
you have the power.
You have the power.
Yes.
To declare a building to be heritage.
Yes, and also the power
Section of the
and
KMC
also
Act.
the power to delist.
Which section of the KMC
420
Act you have the
Your
power to
Lordship,
declare a
kindly-
building to be
kindly, my lord,
heritage?
come to 425.
Yes. And show me the judgment which gives you the power.
Well, that's well today it's not I'm handicapped, but the judgments
We'll have it next week.
Yes, my lord.
And
Well, I can,
425.
well, I can put it by an affidavit, what?
No, I will hear it.
Well, of course.
I will hear it. You
There-
show
there
me
is
the
a-
judgment.
That is well a different fact situation where Heritage Commission is not
There is
taking
no
any
difference.
side. Different fact situation.
No, I'm sorry, my lord, not 425. I'm just pointing out.
This is grant of condition.
No, that's not 425.
This should be 425A, preservation and conservation of heritage
Yes,
building.
yes.
And KMC people are also part of Heritage Commission. They are the member.
সেটা হতে পারে।
This is 425B.
A, B, C, D, all cover relating to the heritage issue.
Yes.
And ultimately, my lord, if it is.
No, read it, mister.
Well, I'm sorry.
Yes.
I'm sorry, my lord.
Where the corporation on the recommendation of the Heritage Conservation Committee
My lord.
and also of the mayor in council is of the opinion that any building should be preserved and conserved for historical, architectural, environmental or ecological purpose, it may declare such building as a heritage building. Show me your committee which has declared that to be a heritage building.
If your lordship permits me, my lord.
You have a committee.
Yes, yes.
Or the committee is
yes,
the
I have
West
a
Bengal.
committee. I have a committee.
Committee is by the West Bengal government or
No. Under this act, my lord, the committee has been formed.
you have a committee?
Yes.
Independent committee.
Independent committee with the Kolkata Municipal Corporation Conservation Committee.
Well, in spite of that provision,
Building.
All right.
in spite of this provision of
Nothing to do with the West Bengal Heritage Commission.
preservation and conservation of heritage buildings, subsequently the new act was, my lord, enacted.
So when you were granting a sanction plan, this fact was not known to you?
Hello?
This fact was not known to you?
Regarding that plan, sanction of the building plan. Well, that might not be, I don't know, my lord, because nowadays it is well mentioned in the assessment record, whether is a particular building is heritage or not. But earlier, my lord, there was some confusion. The parties, my lord, without intimating that there is a heritage building, they approached to the building department. Now this my lord, problem has been obviated because it is known to everyone whether the property belongs to the heritage property or not. Now the position is this, my lord, really he wants, my lord, the delisting. The
Yes.
delisting, my lord, there is a specific provision in this act that the state government's permission is necessary after the, even if I.
Delisting first, he is not asking for delisting. He is asking that. if
There is a prayer.
That's all right. Today he is asking that he should be allowed to construct in terms of the
Sanction building plan.
sanction. Bill.
The sanction building plan he is asking for,
Yes.
the building plan could also be permitted depending on the gradation of the heritage status of the building. Permission also be given. It's not that they're
File,
completely
you
barred.
file your report within 2 weeks. We'll
Yes, ma'am. Deeply obliged.
you file your report. Take down. The petitioner has preferred the present writ petition being aggrieved by the inaction of the respondent municipality. Municipality, comma, which has failed to delist premises number 67, comma, Lenin Sarani. This is Lenin Sarani Road. Is it road?
Lenin Sarani, not road.
Lenin Sarani.
Comma,
67
Calcutta.
Lenin Sarani.
PS. Calcutta kar do, from the heritable property list maintained by the Calcutta Municipal Corporation. Full stop. The respondent has also failed. It is further stated by the counsel for the petitioner that the respondent is not allowing the petitioner to construct his building in accordance with the duly sanctioned building plan dated 16/6/2015. Yes. The petitioner states that he is the absolute and lawful owner of premises number 67, comma, Lenin Sarani, comma, Calcutta, full stop. Upon purchasing the said property, comma, the petitioner caused the same to be, the petitioner got his name duly mutated in the assessment book of the respondent corporation and obtained a building plan dated 16/6/2015, full stop. 16/6/2015 from the competent authority, full stop. It is the case of the petitioner that the said property was included in the list of heritage properties maintained by the West Bengal Heritage Commission. That is a stand. Just recording his stand.
Page 36 may kindly be looked into, my lord.
However, as per the RTI, reply dated 14/8/2024, issued by the Environment and Heritage Department, KMC, it was confirmed that the subject premises have been delisted from the heritage list of the West Bengal Heritage Commission. Full stop. Notwithstanding the above, the premises continue to be reflected as a heritage property in the list maintained by the respondent corporation. Full stop. Learned counsel for the respondent West Bengal Heritage Commission, respondent number 3, West Bengal Heritage Commission, states that the said premises is not in the list of heritage properties maintained by the commission. Full stop. Learned counsel for the respondent Calcutta Municipal Corporation states that the said property has been declared as a heritage property by the Calcutta Municipal Corporation Heritage Conservation Committee. Full stop. Has been duly declared as a heritage property by the Calcutta Municipal Corporation Heritage Conservation
Declared by the Kolkata Municipal Corporation, Heritage Conservation on the recommending authority, then the mayor.
by the Calcutta Municipal Corporation. Has been duly declared as a heritage property by the Calcutta Municipal Corporation in full stop. He seeks and is granted. How much time, Mr. Ghosh? 3 weeks time to file his report by way of an affidavit. Reply to the same, if any, within. Mr. Chakravarti.
Well, within 1 week, it might be collapsed at any point of time, my lord, dilapidated condition,
That's
the torrential
My
rain.
lord, Your Lordship, my lord, appreciate one thing, he is asking for in the prayer, apart from delisting, my lord, he is asking for a plan, according to him, which was issued by the corporation in 2015. By a flux of time, that plan stood last, my lord. There is the question of, my lord, revalidation, renewal, whatever way.
You take
Because
that,
so far as that is, my lord, concerned, he cannot make any prayer on that.
you take that stand in
I-
your reply. Reply to the same, if any. Exception to the same, if any, within 1 week thereafter, list on after 6 weeks.
And renew করতে হবে। মামলা থাকলে renew করতে হবে।
कब होगा 6 weeks? 18. Huh? 25th September.
My lord.
I'll just be. Yes.
Yes.
My lord has gone. My lord has gone through the petition. I understand when I mentioned this matter. My lord, this episode is going on from 2008.
Yes.
Of issuing notices under subsection 411(1).
Yes.
I am not.
So Basu, you are appearing for?
Opposing.
Lordship, I am appearing for Kolkata Municipal Corporation, instructed to appear, but I have not received the brief yet.
I have served. Here is my affidavit of service. I have served everyone. And Mr. Ghosh, as he said, he is there, he is leading.
Give another copy, Mr.
No, I'll give a copy. My advocate.
I have spoken with Mr. Ghosh also. He said, no mentioning notice has been given. He also don't have the brief right
All
now.
those notices are there. Unnecessarily, one should not make comments without going through the records. My lord, I have given the affidavit of service. No, my lord,
They are your own colleagues.
no, my lord,
Yes.
yes, I know. I have not said anything. No, my lord, episode started from 2008.
Yes.
The earlier episode, I am not troubling. The last of such notice under 411 is at page 150. If your lordship is kind enough to take page 150, that your lordship would get in volume 2, volume 1. Yes, volume 1, page 150, the last page, annexure P18. Did my lord get it? Now, this is the last notice under 411. What does it say? To secure the building after demolishing the dangerous portion. Now, my lord, repair the repairable portion, if any, without changing the character and dimension of the existing building under the supervision of empaneled structural engineer. This is the notice. This was challenged. Affidavits by a writ petition. Affidavits were exchanged.
Yes.
And the Honorable Court passed its order at page 177, volume 2. Huh? But who is not?
Yes.
Lordship has got 177. This is the writ petition filed by me. Now, sorry, this is the writ petition filed by Mr. Bose's client. Now, this writ petition affidavits were exchanged, and after completion of the affidavit, the Honorable Court passed its judgment on order. My lord, I am not going to trouble your lordship with the entire order. If your lordship takes page 183, page 183. Is my lord at page 183?
Yes.
Now, my lord, paragraph 10. Considering all these facts, materials on record, and on hearing all the stakeholders, the writ application is disposed of with a direction that the municipal commissioner shall conduct a hearing, considering the report filed before this court by the Kolkata Municipal Corporation dated so-and-so, and take a decision in accordance with the law to give effect to the notice dated 5th July 2021, which has been issued in compliance of the order dated 13 September 18, passed by the coordinate bench in WP number so-and-so. The said hearing is to be concluded positively within 30 days from the date of the order. The conclusion of the hearing is to be intimated to all the parties. The municipal commissioner, then paragraph 18, while considering the matter dispute as directed, shall keep in mind the beneficial legislation being clause 3 of section 412 Kolkata Municipal Corporation, and taking that into consideration, shall pass necessary direction to protect the right of the tenants as per the said provision of the Kolkata Municipal Corporation Act, and to do so is at liberty to take necessary undertaking on affidavit from the petitioner hearing. Now, my lord, I am a tenant of 4,500 square feet, approximately. There is a suit for eviction before the small causes court. Now, with all that background, the commissioner hears me, gives us a hearing and passes an order. That your lordship would get page 200.
But starts at 201.
200, it starts at 201. I'm grateful to my lord. Now, my lord, I'm not going to trouble with the history. I'm just going to come to the last paragraph where he gives the direction, which is at page 203. Did my lord get it?
Yes.
In the above circumstances, the last paragraph, in the above circumstances, hence it is ordered that the executive engineer building department, Borough 7, is directed to, Malad, the words are very important now,
Yes.
to repair / demolish / secure any such portion of the said block in respect of which notice under 411 was issued for the safety of the public or the inmates of the building, if required, on the expenses of the owner. Now, my lord, pausing here. So there are three situations related with the same building. A portion might require only repair, a portion might be demolished, and a portion might be secured. Now, which are these portions? Only the map, a sketch map, as your lordship is aware of now by this time, will only can say. Corporation has to make a sketch map indicating that this is the portion requires repair, this portion requires demolition, and this can be secured. And thereafter, this 4-line is more important. Furthermore, on the basis of the prayers of the tenant, followed by the order of the Honorable High Court, dated so-and-so in WP number so-and-so, tenants are at liberty to inform KMC, Executive Engineer Borough 7, for repair of the required respective tenanted portion, subject to NOC from the landlord/owner. In terms of this, your lordship, in the morning your lordships had said, why didn't you challenge this order? My lord, this order, I told my lord that it inures to my benefit. It's not against me. It doesn't affect me. So I did not challenge the order of the municipal commissioner. Now, in terms of this direction, I make a representation which your lordship gets at 205. Immediately 2 pages thereafter, 205.
Please give me a hearing.
205.
Yes.
The relevant paragraphs over here, your lordship can just mark paragraph 4, paragraph 5, paragraph 6. Then paragraph 7, Roman 4, paragraph 7, Roman 5, and paragraph 7, Roman 6. I am not placing, but these would be the relevant paragraphs. Then my lord would see how the executive engineer deals, which is at page 210. The Lord got it? This is to inform you that information on the basis of the order of the municipal commissioner dated 10/6/2025, which I just now placed, duly communicated to by the letter dated so-and-so. Thereafter, subsequently, letter submitted from, my lord marks this, the owner's end for proceeding of demolition of the structure by KMC, for which they have given consent to make payment for such demolition along with the supervision charges of the KMC. Accordingly, it is forwarded to your end to act in accordance with the law within 7 days. It is given on 6th. 7 days is, my lord, it passed yesterday, that is 13. 7 days. As KMC team will proceed for compliance of the commissioner's order after the expiry of 7 days. My lord, he does not take into consideration the relevant portion of the municipal commissioner's order, by which he overreaches the order of the municipal commissioner. He takes into consideration the letter of the owner, but fails to take into consideration my representation, which just now I showed, my lord. It is at page 205, and takes a decision on the representation of the owner that you vacate and give me the vacant possession, it would be demolished. My lord, today, in the suit before the court, small causes court, as well as in the writ petition, which, my lord, this honorable court had decided and showed, my lord, in affidavit in reply, in no uncertain terms, the owner has said that I am ready and agreeable to provide you the equal area what you are holding today. Now, my lord, this is only a pleading before the court. Now, there has to be thereafter, my lord, as your lordship sees all these matters, an agreement has to come. A proposed plan has to be given to me to show that I have demarcated this portion for you. Second. 3, my lord, I got this. Now, so
You don't get
that agreement has to come.
You don't get distracted so easily, Mr.
When a familiar voice rings, then, my lord, I get distracted. Now, my lord, question is, so there has to be an agreement. One. There has to be a measurement today. If the building is demolished, I say I am holding 4,500. If it is gone, tomorrow the owner will say, who says you are holding only 550 square? I cannot prove anything that point of time because it is raised to the ground.
No, the suits are pending. How can he say that?
In the suit, it is not there. The demarcation of my area, it is all contention. Tenancy is there, my lord, the contention, it is contention, but there is no servitude today.
It is virtually decreed by this.
Now, my lord, the suit is virtually decreed by that he is going to give me. Now, my lord, these three things are one. So, unless, my lord, let them do within 7 days. I cannot, my lord, as a teenager, I am very much conscious about to what extent I can stretch my leg and to what extent I can open my mouth. A owner has its right to demolish and construct, but the court and the law provides me certain, my lord, cushions. I would say cushions.
Yes.
My lord, there is I have annexed what the corporation asked for is it is there, my lord, I have given usual pro forma. My lord sees 176. 176.
Yes.
176 your lordship has got.
Yes.
This is the pro forma. Usually what the corporation asks for from the owner, giving an undertaking. My lord, all these things are not there. Now, my lord, I say that I have, my lord, in that representation at 205, I say that I have secured the building, at least my portion, because I was not allowed to go to others, but I have secured my position. So at least that consideration has to be there. Let him do it as fast as he can. Consider my 205. And following the order of the municipal commissioner, come to a finding. Well, and with the executive engineer, just on the saying of the owner, cannot just say that, like, my lord, I have not taken your lordship to the order of a division bench over here relating to this matter. If your lordship takes page 63, first volume, page 63. This rigmarole is going from 2008. Now your lordship would see what the court opined. 63. Well, it's an order passed by my lord Justice Girish Chandra Gupta, as his lordship then was sitting with Justice Asha Arora. Well, at 63, your lordship would find these BP properties, Dalmia Bharat developer are the owner of this property. It was against Kolkata Municipal Corporation challenging a notice under FAIL 411.
Also, this language is the same.
And that language of that notice and this notice are not troubling, but your lordship would find it is within inverted commas. Now, my lord, would kindly come to page 66. Page 66. I'll trouble your lordship from subpara C. Quoted above. It appears that the intention of the writ petitioner is to demolish the entire building. My lord, page 66. The lordship has. The paragraph starts with from
subpara C.
Yes. Intention of the writ petitioner is to demolish the entire building. In case he is interested in demolishing the building, he can do so. Kolkata Municipal Corporation has not stopped the appellant from demolishing the building. If the writ petitioner is the owner of the building, he can demolish it. For that, permission of Kolkata Municipal Corporation is not required. Prayer for such permission is strange indeed. Why has such prayer been made? The answer is very simple. The writ petitioner is trying to get rid of the tenants, and therefore he is interested in using Kolkata Municipal Corporation as a lever. He wants an order for demolition from Kolkata Municipal Corporation so that the tenants can summarily be evicted otherwise than accordance with the law. And my lord, in the backdrop of this, noting the language of the executive engineer, my lord, the language of the executive engineer in the letter at page 210 echoes the same thing which the Honorable Division Bench noted, which is at page 66. Thereafter, my lord, the paragraph Mr. Banerjee submitted that Kolkata Municipal Corporation should have taken steps under subsection 4 of 411. But before that, he must realize subsection 4 gives power to Kolkata Municipal Corporation to be exercised in respect of that portion of the building which is deemed by the municipal commissioner to be in ruinous state. The act does not give any power to the municipal commissioner to direct demolition of a building, partly or fully, which the owner deems to be in a ruinous state. The writ petitioner is interested in obtaining an order from the KMC directing the entire building should be demolished because the owner deems the building in its entirety to be in a ruinous state. For that purpose, he has repeatedly been invoking powers of the writ court. He should realize the court cannot pass such an order, nor can the law be used for an ulterior purpose, for the purpose of defeating the law itself, which is intended by the writ petitioner appellant. While he has ostensibly challenged the notice under 411 for lack of particulars, he is interested in an order for demolition of the building. High Court cannot issue any writ in the nature of mandamus directing any person to authority to act illegally. This is precisely what he wants. The appeal is therefore dismissed with a cost of 10,000. Now, my lord, I will fail in my duty if I do not show, my lord, the affidavit in reply filed before this court in the other matter. Copy ache. Do you have a copy of the affidavit in reply? My lord, pardon me, I have read and I have marked it. I apologize before your lordship. No, for marking. For marking. My lord sees paragraph 4F. Paragraph 4F.
Yes.
My lord, paragraph 4F, your lordship will see.
Yeah. Yes.
If your lordship takes it an undertaking, I have got nothing to say. Only thing, three things your lordship would direct. Before the demolition, a joint survey to ascertain my area has to be there. 1, 2, an agreement to give effect to that undertaking, the affidavit in that petition has to come to me. 3, a proposed plan. He has to give a plan subsequently to get it sanctioned. But a proposed plan prima facie should be given. He admits me. So that has to come to at least show that this is the portion demarcated for you. Your lordship just fixes it as fast as the Moses client will give it, Malad can dispose it of. And till then, Malad, the corporation should stay. in
Yes,
their
Mr.
hands
Basu.
of- Not my, Khali my.
Lordship, one
They
thing I
do
would
it,
like
but-
to submit, though I don't have the papers today. In earlier few proceedings, I appeared on behalf of the Kolkata Municipal Corporation.
Copy আছে।
As I can recollect, Lordship, as per the direction of the Honorable Court, structural engineer of Jadavpur University has filed one report in this matter regarding the structural stability, Lordship. That should be considered also.
Once I leave. Malad, from the bar, she cannot make any submission when the commissioner has passed his order. Because from the.
I'm not making any submission from bar. As I appeared in the earlier proceedings, from that I am making the submission.
Malad, from the bar or by a way of an affidavit, I cannot develop or insert fresh reasons which is not there in the order. Court directed municipal commissioner to hear and pass an order. He has passed an order. I have shown, my lord, the paragraph which is in my benefit. Now today, if that is not considered by the municipal commissioner, it cannot be added from the bar. That is what I wanted to say.
Yes, Mr. Basu.
Kindly come to page 79.
Page 79. Before you start, Mr. Basu, why can't we refer this to mediation?
Mediation. Structural stability, what mediator will do.
Not structural stability. The fact that his portion should be protected.
That is the only issue.
That's
Because
we are not on the structural
problem is
stability.
with me. If today it collapses, I will be behind the bar.
That's all right. This problem has been subsisting since the year 2008.
This is not the problem. Yeah, that's why you want to show to us. What mediator will do? If it is
Mediator
same-
will do what mediator can do, Mr. Basu. This will never come to an end till the time you don't really decide his share. You give him a plan, mark a portion to him according to the undertaking which you have given and according to the law, where you have to rehabilitate your tenant.
No plan now to reconstruction.
You get into an agreement with him,
Whenever I will construct, here and now.
you do that.
Here and now. Whenever
That's the
I will
reason
construct,
why,
let it happen.
Mr. Basu, why do you think I'm trying to refer it to mediation?
Here and
Get
now.
this resolved?
But here and now you will do it. Not.
Here and now, it will not happen till the time you don't really put that in paper. You have to put it on paper.
Tomorrow I will.
You
come
have
to
to
an
put it on
undertaking That whenever I will construct, I will give him possession as he is occupied.
And time limit. Just 2 days back, my lord, the Honorable Bombay High Court has decided one matter which says, my lord, if it is so, my lord, I have to be provided with the transit rent. That is for the period I am out till the period, till the time he puts me in after the completion certificate. For this period, I am entitled for the transit rent. Well, it cannot be just across the table. It requires a negotiation. One has to sit. The
That's it.
owner has to sit.
That
with
is the reason
tenant.
why I want to send it for mediation.
But I
If
want
both
to-
the parties agree, this can go for mediation. Otherwise, we'll pass an order.
Let me try to convince my lord. What my lord underfriend is saying is must have a statutory force. Let us see, let us
Mr.
study what
Basu-
section 411 and 12, where these provisions are there.
We have seen section 411 in many matters. Till the time this issue doesn't get resolved, as far as his being put back whenever the development takes place, and you enter into some sort of an agreement with him, this will go on.
I am saying now I have no plan.
Fine, you have no plan. You can get into an agreement, you can decide his portion, you can mark his portion, you can agree on the rent if you want to pay, at least make an endeavor.
Well, there are many probabilities which can be there.
I cannot make myself clear. If today I don't, what is the issue here? Issue here under section 411, building is insecure, it is a collapse. If it collapse, and something happened, entire liability is on me, on the owner. That's why, my lord, it requires to be ascertained whether the building is in dangerous condition.
So today, the order which has been passed by the executive.
I'll come to the order later. That's why, my lord, all blame on me. Now kindly, I request your lordship come to page 79 and mark the date.
It's 79.
Good is that? You would have good. Well, again, I call it that.
Yes.
Can you mark the date 13th September 2018? Kindly come to. This is the writ petition filed
Page
by
75, page 75.
79. This is the writ petition filed by my landed friends client.
Yes.
13th September 2018. What is the order passed here? Kindly come to.
আমি করেছি তো
81 last line in such circumstances the petitioner is at liberty to approach the Kolkata Municipal Corporation authorities for the purpose of repairing the rear building of the premises in accordance with law. Upon such approach being made, Kolkata Municipal Corporation authorities are at liberty to consider such application in accordance with law. KMC authorities are at liberty to reject such application if they deem it appropriate. If they reject the same, they will give reason for rejection. They will also afford a reasonable opportunity to the petitioner to correct the proposal for repair if the initial proposal is rejected by the KMC. KMC authorities will ensure that the work of repair is done strictly in accordance with law. It will ensure that there is no deviation from the original sanction granted and that the work undertaken by the petitioner is limited to the repair of the rear portion of the building is concerned. Then, my lord, it is clarified that then, on the prayer of the learned senior advocate appearing for the petitioner, 2 weeks' time is granted to the petitioner to approach the corporation authorities for repair. It is clarified for the petitioner there is not responsible for any damage at the rear building of this premises concerned. I was protected. Well, let kindly inquire whether in terms of this order, which they have obtained by filing this petition, any approach has been made to the corporation authority.
Yes, it has been done.
Let us see.
Yes,
Let us
my lord, would kindly come to page 200. Kindly come to my representation to the corporation after the municipal commissioner's order, which is at,
No.
of course, yes.
No, please.
Why not?
You-
I have stated facts.
You
I have
give-
stated facts.
Oh, please.
Four, I have indicated, my lord, the paragraphs
Can you
4,
see the
5.
date?
Yes, I'll show.
Can you see the
I'll
date?
show.
Page.
My lord, page 206, we further state. We, Messrs. Magnum Enterprise, which is registered partnership, is a monthly tenant under the landlord. We hold, my lord, I have indicated
where are
how
you?
much area I hold.
Where are you reading?
Page 206.
I say compliance of 2018.
Yes,
order.
it is there, it is coming. Just hold your breath for
You give
1
the
minute.
Date.
I am giving the date.
When you were
Now
filing,
the premises number, date of the
when you were filing this application.
11 and now, my lord. The Magnum is a tenant of the said premises since 74. Originally, this is their building situated in the rear portion of the premises is structurally secure and repairable, as would be clear from each of the notices issued by the municipal authorities. My lord, just gives me 4. In the aforesaid order of 13 September 18, the undertaking of the landlord was also recorded that they assured that they will not cause any obstruction as apprehended by Magnum. It is submitted that the Magnum, being bona fide tenant occupier, on the other hand, landlord is there. I have myself read it. How can you say it's not there?
Para 5, it is, we have carried out the repair of.
Yes, I'm grateful.
Question to myself. It requires an application to be made with the corporation. Corporation will sanction it, then you can repair only.
Maybe some minor repair.
Everything was there.
Maybe some minor repair.
No, there cannot be a minor repair. I will come in thereafter.
Yes.
So, my lord, the order of 13 September 2018 has not been complied with at the instance of the petitioner who obtained this order. There is no application before the corporation.
So that 13 September order, 2018 order, that also protects you.
That was put me for if something happened, I am not responsible.
So good. Let the building fall.
No.
Nobody appealed.
Then, my lord, this order
No
is
appeal.
granted for a sanction for repair. Not taken. Not taken. Then, my lord,
Oh, he's-
corporation give another notice.
Yes, one.
That was also challenged. Now thereafter, my lord, in an order passed by Justice Sarkar, can you see this order?
আরে ওই শম্পা সরকারের অর্ডারটা দেখাচ্ছে যে
আছে।
যাদবপুর এই দেবে
In terms of this order, my lord, a structural engineer was appointed. What is the conclusion there?
Yes.
In this property, one person was appointed, can you see the report? Kindly come to last page. This report on in terms of your lordship's court order. In consideration of the detailed physical study of the building structure, any restoration activity without demolition in part or full cannot be a durable solution, particularly of western building block 2. This is the conclusive report, not challenge up till date.
I am not challenging because your commissioner has jettisoned that portion. Yes.
So this report is still holding the field that it is not repairable. So now they cannot say that we are going to repair it.
Yes.
Repair it. That is
Yes.
conclusive proof. Now, my lord, so far as this part, my lord, I have to concede. So far as this part is concerned, last. Don't record my conclusion, then I will be beaten by my side.
Yes.
This last order, the last order, page 210, that should have been passed, my lord, as the order impugned. According to me, that's the order impugned, that page 203 in conclusion. Is given a liberty to them to be heard.
I have
That
exercised.
has
Not been.
not been come.
That's clear.
He's been heard in 5 written courts also. He was there.
Which one?
Yes.
This is not there. It's
No,
about.
let me clarify myself.
After hearing him, this order has been passed. He's filed written notes also.
It was not these, thereafter. That is very important. Right.
Yes.
Thereafter, his representation has
Yes,
been
yes,
considered.
yes.
That I'm correct. This representation, this order itself says, my lord, that to repair was issued to the safety of the prayer of tenants, followed by the order of Hajan sir. Tenants are at liberty to inform KMC Tribunal for repair request respective tenant portion 552 NOC from the landowner.
I've done.
The last part, he has sent it. I don't know how it has been received by the corporation. Or the date is 29 July and this order has been passed on
205 বাদিকে দেখো।
and on 6 August.
Yes.
But after the activities of Kolkata Municipal Corporation, as we know, it may not have reached there.
আরে it has reached. এদিকে দেখ।
And I cannot finish. And my lord, see, my lord, kindly see. Only stamp is there. We have the history in our court.
Yes.
In a little triangulation, madam. A particular advocate who is no more with us, he was served on the GP.
কি বলে আছে?
In a
হচ্ছে জজ।
ultimately, State Justice Ganesh Rai detected that he has a stamp of Garnet GP. Receipt, contest not verified. And that has been filed as an affidavit. But can you see there is no stamp, no signature? Who will take the responsibility? It has reached to them or not? And seal, my lord knows how the seal are prepared.
Seal that is prepared.
I'm not saying so. Can you see there is no signature? Had it been received, that there should have been a signature.
The height of it.
Corporation will, my lord,
Height.
enlighten my lord, whether that has been served or not.
Height.
But had it been served,
সিগনেচার নেই বলছে
there is no signature. Do you think-
সিগনেচার নেই বলছে কর্পোরেশন সিগনেচার না দিলে আমরা কি করব
Only so,
Now,
kindly consider this submission of.
Mr. Basu, I can do only one thing. Either I stay this or I send you before the mediator. You come back after 2 weeks. We decide this issue or 3 weeks, whatever you want. If not,
My prayer would be kindly,
I'm inclined to stay it for a period of 3 weeks.
kindly set aside this order, page 210. And let the corporation decide this application which the impugned order which has not been challenged.
Kindly mark that this order is not under challenge.
I already said,
I said, it's my benefit.
It holds good. From there, a hearing has to be given to them and pass a final order.
বুঝতে পেরেছো?
But still, I am doubting whether my lord this application has been
যাবে।
served upon the corporation or not. There is no signature. Can you see? Who will take the responsibility? At the top, 205.
Resubmit.
205. Top. Left hand side. No signature. Only the seal. None to take responsibility that it has been received by him and sent to the concerned officer. Who failed to discharge his duty by not considering? Because Madhu will be finding fault on him that it has not been considered by him.
this will only get resolved if you sit with him and work out the modalities. This is never going to get.
Only only one tenant is left out. Other all.
So he's the one who's left out.
Yes,
Sit
yes,
with
they're
him.
not coming.
Impossible demand.
Sit down, let us sit.
I will not.
Sit, let us sit.
Impossible demand. That's why the litigation is going.
কি করেছো তোমরা?
But Kelly, my submission would be well subject to what my lord is thinking. Kelly, should I say it is 210? It is 210. Holding the order of the.
Yes, Mr.
Ghosh.
Ghosh.
There are lots of proceedings in respect of this particular building.
Yes, 4-5.
Well, LOC has also seen the report submitted by the engineers, my lord, independent engineers appointed by the High Court.
Yes.
And thereafter, my lord, the matter went back to the Kolkata Municipal Corporation for consideration. Now, my lord, Mr. Mukherjee, possibly, my lord, relying on the penultimate paragraph of this, my lord, the order 10, it is
This is not under challenge.
not challenge, rely করছে না। 10 June 2025. So that's right. Well, 10 June 2025 says, my lord, three things are there. Repair, demolish, secure any such portion of the said block in respect to which notice under section 411(1) of the Kent Act was issued for the safety of the public and of the inmates of the building if required on the expenses of the owner. This is the penultimate paragraph. Three things have been mentioned: repair, demolished, or secure. Therefore, either the situation may happen or may be required to, my lord, execute this order. It has not been said that it could be repaired or it could be demolished or the secure. Executive engineer has been, my lord, asked to look into that issue. Therefore, my lord, if it is ultimately found that particular block or portion that it is not repairable, this is one way. Then, my lord, if he comes to the ground, it is to be then demolished. If it is not repairable, then it can be secured. Then ultimately, when the conclusion is to be demolished. Now, my land has possibility objecting regarding the demolition part.
No, I'm not objecting. I see.
Not at all. Read further.
Or the inmates of the building required on the expense of the owner, furthermore on the basis of the prayer of the tenants.
Prayer on the basis of the prayer of the tenants, followed by the order of the Honorable High Court dated 39. Tenants are at
to
liberty.
inform the KMC, executive engineer for repair or of required respective tenanted portion subject to NOC from the landowner.
Yes. So they have approached the executive engineer by the letter dated
205.
Not received.
whatever, they'll give it again.
Prejudice করছিস, ফালতু।
Without considering that,
তাহলে
they have passed an order.
আরে, you have been asked to consider.
Then they have passed an order without considering it.
শুধু এই ডকুমেন্টটা চ্যালেঞ্জ করা হচ্ছে
ঠিক আছে। The report may be considered, report that have to be on record.
Along with my representations that I have also given a Malad chartered engineer's report, which is at page 85.
Passed by the court and report has been filed.
Very well, very well. You cannot just brush it aside.
Only issue, my lord, whether the building in such a condition that whether it could be repaired for the purpose of securing or it is to be demolished. It cannot be anybody's case where if a building is made really, is a developmental condition that it cannot be retained, then it only option to demolish it, because for the inmates and also the other persons, that is the only issue.
So you consider it.
My lord.
And before your lordship starts dictating, section 411, subsection 4. 411.
4,
Yes.
subsection
No,
4.
no, 4.
411, 4.
Yes.
Subsection 4. Yes.
I'll just read it.
I know it.
I'm grateful.
He knows it. This is the same section in Delhi. I'm grateful to him.
The petitioner in the present writ petition challenges the order dated 6th of October 2025 issued by the executive engineer bracket C building department, comma, Borough 7, Calcutta Municipal Corporation, comma, whereby it was communicated that, comma, upon expiry of 7 days, comma, KMC officials would proceed to implement the municipal commissioner's order dated 10/6/2025. Full stop. By the said order, comma, the municipal commissioner directed the executive engineer, C, building department, Borough 7, to repair, demolish, / secure any such portion of the said such portion of the western block 2 of premises number 11, Abhanindra Nath Thakur Sarani, comma, Calcutta, comma, in respect of which a notice under section 411(1) of the Calcutta Municipal Corporation Act 1980 bracket mein KMC Act bracket close has been issued, comma, if so required for the safety of public and the inmates of the building, comma, and to do so at the expense of the owner. Full stop. This matter has a checkered history, comma, involving multiple litigations between the landlord and the tenants in respect of western block bracket mein dal dena, block 2 of premises mentioned above. Full stop. Respond number 5, comma, the landlord of the premise, comma, and the petitioner herein is one of the tenants thereof. Respond number 5 is the landlord and the petitioner herein is one of the tenants thereof. Full stop. And which was the first suit which was filed?
The suit is at page 30. Suit that has before the
Yes.
small causes court. It is
And
at page
ejection suit number 110 of 2005.
E. Well, there's a E with that 110 E. The number is 110 E.
110 E. 110 E is pending before the, is still pending, right?
Yes.
Is pending before, comma, is pending before the chief judge, comma, presidency small causes court, Calcutta. Full stop. The respondent corporation initially issued a notice under section 411(1) of the KMC Act 1980, full stop. The Honorable Division Bench of this court, by order dated 24/8/2014 in APOT 179 of 2014, comma, in an appeal filed by the landlord, comma, quashed the said notice on the ground that neither the specific dangerous portion of the building was identified, nor was a sketch map annexed to the said notice. Full stop. Thereafter, the respondent corporation issued second notice under section 411 of KMC Act, which was set aside by this court wide order dated 13/1/2015 in WPA number 11271 of 2014, a writ petition filed by the landlord. Full stop. The appeal against the said order was also dismissed. On 23/12/2017, the respondent corporation issued third notice under section 411 of the KMC Act, and subsequently displayed on a board outside the building, declaring the building to be inverted comma a dangerous building. Full stop. The petitioner challenged the said notice in WPA number 435 of 2018. Full stop. By an order dated 13/9/2018, this court disposed of the writ petition by granting liberty to the petitioner to approach the respondent corporation with a prayer for renovation / repair of the building, and directing that the rejection of such application must be by way of a reasoned order. Full stop. In terms of such order, joint inspection was carried out on 30/11/2018. Full stop. Thereafter, by order dated 26/12/2018, the respondent corporation rejected the petitioner's application for renovation / repair. Full stop. The petitioner challenged the order in WPO number 80 of 2019. Full stop. By order dated 4th January 2021, this court disposed of the writ petition granting liberty to the petitioner to submit a fresh proposal for repair, and directing the corporation to dispose of such application within 3 weeks within 3 weeks. Full stop. Within 3 weeks of receipt. Within 3 weeks of receipt. Full stop. Subsequently, the respondent issued fourth notice under section 411(1) of the KMC Act, directing the owner / occupier to repair the repairable portion and demolish the dangerous portion of the building. The petitioner claims to have undertaken repair renovation in respect of their portion without any application. Full stop. In the meanwhile, respond number.
The submission, I object to that.
Yes. The submission I'll record later, sir. क्या लिखा है? Respond number 5 filed WPO number 1175 of 2021 seeking demolition of the building. Full stop. In the writ petition, respondent number 5 stated their willingness to rehabilitate the petitioner and other tenants in accordance with law, comma, after raising the new construction, comma, subject to the outcome of the civil dispute in the eviction proceedings, full stop. By an order dated 30th/1/2025, this court directed the municipal commissioner to decide the dispute, keeping in mind section 412(3) of the KMC Act 1980, full stop. Pursuant thereto, the commissioner, the commissioner, Municipal Corporation of Calcutta, passed the order dated 10/6/2025, full stop. While order dated 10/6/2025, comma, the commissioner directed ये यहाँ से आप इसको पढ़ो, ठीक है, ये पोर्शन, ये पोर्शन, द कमिश्नर डायरेक्टेड सो एंड, उसके बाद आप डाल दो. Thereafter, the executive engineer issued the impugned order dated 6/8/2025. Full stop. उसको भी आप यहाँ पे कॉपी करो. ये पेज 203 है, ये पेज 210 है. This from tick to tick, इसको कॉपी करो. Full stop. All right. ये दोनों कॉपी करो. फिर उसके बाद लिखो, the learned counsel for the petitioner submits that the municipal commissioner's direction was to repair, demolish, demolish / secure the building, comma, whereas the official of the respondent corporation have misinterpreted the directions and have passed an order which is a complete demolition, which renders complete demolition, which renders to be a complete demolition order in respect of the portion occupied by the petitioner, and there is no element of any repair or consideration of the prayer of the petitioner in terms of the order passed by this court in WPA number 435 of 2018, and also the order passed by the municipal commissioner on 10/6/2025. Full stop. Learned counsel for the petitioner submits that the impugned order is contrary to the directions passed by the commissioner in its order dated 10/6/2025, and also in terms of the earlier order passed by this court. Full stop. He further submits that he had made a representation dated, what is the date? 29 July 2025, in terms of, yes, in terms of the directions passed by the municipal commissioner, while its order dated 10/6/2025, but the same had not been considered by the executive engineer at the time of passing of the impugned order dated 6/8/2025. Full stop. Learned counsel for the private respondent number 5 states that the commissioner has duly passed the order dated, the executive engineer has duly passed the order dated 6/8/2025 in compliance of the directions given by the commissioner in its order dated 10/6/2025. Full stop. He states that the petitioner had not made any representation before the authority concerned, and there is no signature of receipt from the office of the Calcutta Municipal Corporation on the application of the petitioner dated 29th July 2025. Full stop. The said fact is controverted by the learned counsel for the, yes. But that issue is over. Your commissioner is giving the commissioner himself. No, sir. Commissioner himself is giving him the pardon. Learned counsel for the learned senior counsel for the respondent number 5, Mr. Saptanshu Basu, submits that the petitioner has carried out the renovation work in defiance of the order passed by this court. Full stop. He states that that while order dated 13th of September 2025 in WPA number 435 of 2025. WPA number, what is the WPA number? 23.
Then
Yes.
don't make submission.
That's what I'm saying. That's why. That's, you made two submissions. No, you made two submissions, Mr. Basu. One, you said that he has carried out repair. No, when he read it out that he has, you said he has done it illegally. All right. Change. Learn. No, it's okay. It's okay. Yes. I have already taken care of that order. I have noted it down. क्या लिखवाया है उसको चेंज करो. The learned senior counsel for the respondent number, Mr. Basu, learned senior counsel for the respondent number 5, states that the directions given by this court in WPA number 435 of 2018, while order dated 13/9/2018 has not been followed by the petitioner, wherein liberty was granted to the petitioner to make an application for renovation. Full stop. He states that the petitioner had not made any application for the renovation or repair of the his building, of his premises. Full stop. He further states that the petitioner has given up his right in terms of the earlier order passed by this court. Full stop. The said fact is controverted by the learned counsel for the petitioner, who states that the order of the order passed by the municipal commissioner dated 10/6/2025 has given him the right to make a representation for repair and renovation, and the same fact is also reflected in the order passed by the municipal corporation, where he has recorded that in terms of the direction passed by this court in WPA number 435 of 2018, in terms of the directions passed by this court in WPA 435 of 2018, the petitioner is entitled to approach the executive engineer with a representation for repair renovation of the premises under his control. Full stop. Mr. Ghosh.
My submission, illogically recorded a short submission, because the municipal commissioner was incumbent upon the municipal commissioner.
Yes.
To pass the order in terms of the direction as dated 31st January 2025.
Yes.
Because once I remember, in that the order, specific direction, what is to be taken into consideration for passing the order.
Yes.
The municipal commissioner, upon taking into consideration, pass the order. It was not required that the person, it was not also required, mentioned that the parties to be heard. The court said that the issue to be considered in terms of the direction, what is to be taken into consideration, that was mentioned. On that basis, this order was passed. Now, my lord, the three things were there. The executive engineer, the order which has been executive engineer, the instruction which has been issued. It is, my lord, in fact, my lord, in view of the order of the municipal commissioner.
All right, learned counsel for the respondent corporation, Mr. Ghosh submits that the order passed by the commissioner dated 10/6/2025 was in compliance of the order passed by this court on 30th/1/2025 in WPA number. What is the writ petition number in which the order has been passed?
My lord, the order.
1175, if I am not mistaken. 1175 of 2021.
1175 of
Dated
2021.
30th January 2025.
Dated 30th January 2025. He submits that the order passed by the commissioner is in compliance with the direction of this court, and that the commissioner has nowhere granted the opportunity to the tenants to make any further representation, full stop. The said submission is absolutely contrary to the order passed by the commissioner dated 10/6/2025, where it has been specifically recorded by the commissioner that the executive engineer building department borrow 7 on the basis of the prayer of the tenant in terms of the order passed by this court in WPA number 435 of 2018, and liberty was granted to the tenant to make representation before the executive engineer for repair of his tenanted portion, subject to NOC from the landlord owner, full stop. This court has heard the submissions by the counsel for the parties and has produced the materials on record, full stop. This court is in agreement by the submission made by the learned counsel for the petitioner, wherein he has stated that in compliance of the order dated 10/6/2025, he had made a representation before the executive engineer building department borrow 7 dated 29/7/2025, but the same has not been considered at the time of passing of the impugn order dated 6/8/2025, full stop. Since the executive engineer has failed to comply with the directions issued by the municipal commissioner and has ignored the directions of the municipal commissioner while its order dated 10/6/2025, the order passed by the executive engineer dated 6/8/2025 is hereby set aside. The executive engineer is directed to pass a fresh order in compliance of the direction given by the municipal commissioner while its order dated 10/6/2025, and in terms of the earlier directions passed by this court, full stop. With the, I'm not saying anything about that. That is not something, I am only saying he has to pass any order in compliance of the municipal commissioner's order.
That's what is required.
That's all. He will definitely.
Everyone would be there, give a hearing where all parties.
See, that, see, if you see, only tenants. I am not modifying the order of the municipal commissioner. That is not under challenge. He can always call you if he needs any evidence. See, this, Mr. Basu, this order, I'm not modifying the 10th of June order. I am only saying that the executive engineer shall pass any order totally in compliance with the direction given by the municipal corporation, while its order dated 10th of June 2025. I'm not, if I add, then I'm modifying the order. I will not modify. Here, he represented, if you are aggrieved, Mr. Bas, then you are aggrieved. If you are, no, you are aggrieved, you are, no. Mr. Basu, the hearing has only been granted to the tenant in terms of the order passed in writ petition 435 and wide order dated 13th. No, not at all. If no, Mr. Basu, not at all. If you are aggrieved by the order of the municipal commissioner, whereby you have not been granted the right to be heard, you challenge that order. You challenge that order. If he has not provided, you challenge that. You challenge that. Nobody is stopping you from challenging that order, but that order doesn't give you the right. I will not give you the right. जहाँ वो लिखा ना, the executive engineer shall grant a fresh order within a period of 6 weeks. How much time is it? Mr.
4 weeks here, 4 weeks.
Within a period of 4 weeks. 4 weeks. With the above direction, the present writ petition is disposed of. I tell you, Mr. Basu, you you go before the mediator, this will not get resolved. Use your good offices then, if you don't need a mediator.
At least in Bengal, before mediation, at least 5 male mediators effected. Para level, bench level, level, and then now particle level.